Module L, Editing. The most important part of our everyday English has not to do with grammar, or with spelling, or with punctuation. It has to do with the right use of words as to their meaning and logical connection. And this may be learned by study and by care at almost any time of life. Richard Grant White. Words are the only tools that lawyers have. Just as a skilled carpenter wouldn't drive a nail with a screwdriver, a skilled legal writer wouldn't use fortuitous when he or she means fortunate, or infer when he or she means imply. Some initial thoughts on editing. This is about your credibility with the court. If you want the court to trust you, you need to sweat the details. One judge cautioned, "We judges tend to become suspect of any argument advanced by an advocate who produced shoddy work. I have little trust in an advocate who files a document that contains misspellings or poor grammar." In theory, then, you really should spend as much time editing as you do writing. When you are editing, don't fall in love with your own prose. You are not preparing a literary masterpiece. You're preparing a tool to help someone figure out an answer to a dispute as concisely and quickly as possible. Be brutally objective. I also would recommend that you edit on paper with a red pen or pencil. Do not do it on a computer. You want to read a document the same way a reader will. If you do this on a computer screen, then you're bound to miss something. The 5 steps of editing. The process of editing has been described as changing every page to a paragraph, every paragraph to a sentence, every sentence to a phrase, every phrase to a word, and then cutting out the extra words. When you edit, you are constantly honing your message. So first, you should focus on organization, or the flow of your brief as a whole. Have you developed your arguments first? Are your thoughts in sequence? Is the transition clear? Does your central point emerge quickly and clearly? Is the logic explicit and sound? Do the paragraphs, themes, and thoughts flow from one to the next? Have you considered possible counter-arguments or alternatives to your arguments and framed yours in light of those? Is your tone appropriate? Could you be bolder in your thesis? Or have you overstated it? Eliminate emphasis that has been added as you wrote. You may want to bold or underline a particular point, but it will not be noticed if you overuse emphasis. So cut out what you've included as you wrote and then add it back in as you edit. Furthermore, test your cadence. Read it aloud. How does it sound? Does it flow? Look at your paragraphs next. The general rule is to only include one thought or theme per paragraph. Are your paragraphs too long? Never keep one that is longer than a whole page. You should hardly ever have a paragraph that's more than 3 or 4 short sentences. Ask yourself, does each paragraph have a topic sentence? Do all paragraphs fit within the heading? Do you need more or different subheadings? Then focus on each sentence. Eliminate rhetoric, hyperbole, and overstatement. Avoid metaphors and hypotheticals. Make sure your quotations are correct. Vary sentence length. Use short sentences and break long sentences into half when necessary. On the other hand, combine thoughts when appropriate. Eliminate any negative references to counsel or the lower court. Eliminate block quotes if possible. If the quote really is essential to make a point, explain the substance of the quote in the sentence leading into the quote so that the court gets the point. Eliminate footnotes. Eliminate repetition and redundancy. Avoid "in other words." Watch placement of dependent clauses. It should not read, "The court granted summary judgment because the causal link was not established." This suggests that you're agreeing the link was not established, but what you really mean is the court erred in not finding the link. Rather, it should read, "Ruling as a matter of law that the causal link was not established, the court granted summary judgment." Make passive into active tense. Passive can be appropriate when the actor is obvious or you want the actor to be ambiguous, but limit your passive sentences to less than 10% of your brief. After you have reviewed the sentences, then turn your focus onto every word. According to Jonathan Swift, style is the right words in the right places. Use the simplest, not the fanciest word. Look at your verbs. Can you strengthen any of them? Use active rather than passive. Get rid of adjectives and adverbs. Use verbs. Frequently, we tend to use nouns, adjectives, adverbs, and clauses to do the work of verbs. Get rid of any overstatement. Understated prose is the best form of expression. Pretend you're talking across the table to someone in a quiet room. What kind of words and tone would you use? Keep in mind that overstatement appears egomaniacal. Get rid of redundant words. Get rid of legal jargon. One attorney advises to use the McDonald's test. If you were reading the document you drafted aloud in McDonald's, would people understand what you were saying? Don't use ancient verbiage like heretofore, hereunder, and said document. Would you go up to the counter at McDonald's and say, "Said milkshakes, I will quaff it"? No. Get rid of tired cliches. Is the word you're using the right word? Is the word the strongest word to make your point? Do not overwrite. Write clearly and simply as possible. Once you've done all of this, then set the brief aside for a while, at least a day, and then come back and edit again. It will seem fresh then, and you'll catch things you missed as you were reading over the brief before. Spend at least a full day not looking or thinking about your brief. You need the mental break, and you need an interval to switch from creative mode of writer to critical mode of editor. The final read-through should be exclusively devoted to seeing whether certain points can be put more clearly, more vividly, more crisply. The bottom line is that every word that is not a help is a hindrance because it distracts. Judges who realize briefs are wordy will skim them. Judges who find a brief terse and concise will read every single word. Double check. Is the tone proper? Did you eliminate the non-essential words, sentences, and paragraphs? Did you spell check? Did you eliminate all typos or grammatical errors? Proofreading is essential. If you are sloppy, you lose credibility. And when it comes to spelling, do not simply rely on spell check. If you mistype a word, yet your typo is a real word, spell check will not pick up on that. I had a brief at the Court of Appeals that had such an error. It was quoting the language of a statute, and rather than saying public, the word used was missing the L. Let's just say that the reading took on a completely different meaning when using the word pubic. And, in a twist of fate, that brief was actually written by the legal writing professor I had for this class. The point is that you always need to carefully proofread because the tools that you use may not always find your mistakes. Have someone cold to the case proofread your brief. An intelligent layperson is a good judge of the persuasiveness of the brief. If a word, sentence, or argument is hard to understand, the problem is with the text. Another law student or lawyer can give a quick read-through, about as quick as the judge's will be, not long. If the person reading it does not understand it the first time, though, it definitely needs some work.